Hello, my name is Michael Gerrard. I'm a professor at Columbia Law School in New York, and I'm the director of the Sabine Center for Climate Change Law. Today, I'm going to be talking to you about climate change litigation in the United States. Our center has this website on which we post all of the climate change litigation in the world, separately the US climate change litigation and the litigation in other countries. As you can see, the United States is far and away the largest source of climate litigation in the world. We've counted a total of almost 1,600 cases globally, and of them, 76% are from the United States. Australia is a distant second at 98 cases, the UK a distant third at 62 cases. The amount of climate change litigation has grown both in the US and globally. What this chart shows is the annual litigation. In blue is the cases in the US, red are the cases elsewhere in the US. The 2020 line is short just because this is only a partial year that's shown here. But as you can see, climate change litigation really took off around 2007 and has grown since then. The cases in the United States are shown here. By far the largest number of them are cases under the National Environmental Policy Act, which is the US law that requires environmental impact assessment for significant projects. Several states in the US have their own equivalents to this, and that's also a large number of cases. So these are mostly cases saying that the governmental review of a particular project did not adequately look at climate change. But we also have many cases under the Clean Air Act and the Endangered Species Act and several other statutes. During the Trump administration, there was a great deal of litigation challenging the actions that administration was taking to revoke the climate regulations that had been adopted under President Obama. So we had a large number of those cases, and many of them were successful. Many of these cases defeated the efforts by the Trump administration because it did not follow the necessary administrative procedures. Another important line of cases we've seen in the United States is cases against fossil fuel companies or fossil-fired electric utilities to try to reduce their greenhouse gas emissions or get money damages from them. One important case was brought by Connecticut and New York and several other states against several large power companies that had coal-fired power plants. It sought an injunction requiring these power companies to reduce their greenhouse gas emissions. That lawsuit was ultimately dismissed by the United States Supreme Court on the grounds that when Congress enacted the Clean Air Act in 1970, it gave the Environmental Protection Agency, EPA, the exclusive authority to decide appropriate levels of greenhouse gas emissions. There was also pending around that time a lawsuit brought by a village in Alaska that was endangered by the melting of the ice and sea level rise. It sued several fossil fuel companies. It was seeking money damages. That lawsuit was also dismissed based on the power company case I just mentioned. Those cases were based on federal law, but they left open the question of whether these kinds of lawsuits could be brought under state law. So we now have about 20 of these cases that have been brought under state law against fossil fuel companies seeking money damages for the damages caused by climate change. All of them have been held up for several years on the question of do they belong in federal court or state court. The defendant fossil fuel companies would rather be in federal court because then the power company case that I mentioned might govern and lead to the dismissal of the cases. The plaintiffs, which were mostly cities and states, would rather be in state court. They think they have better odds there. Another related line of cases concerned the allegations that some of the fossil fuel companies engaged in deceptive advertising and public relations and otherwise generally lied to the public about the dangers of climate change. The major oil and gas companies have spent a great deal of money on promotion and advertising, as shown in this chart. So that's the basis of some of these lawsuits. One of those has gone to trial. It was a suit brought by the state of New York Attorney General against Exxon, and Exxon prevailed in that trial. The court was not persuaded that Exxon had engaged in the particular kind of deception that the plaintiffs were alleging, that the New York Attorney General was alleging, and that's that case. Another very prominent case in the U.S. was Juliana versus United States, brought by about 20 young people against the federal government. And as you can see here, that what they were seeking was an order that the defendants, the federal government, prepare and implement an enforceable national remedial plan to phase out fossil fuel emissions and draw down excess atmospheric carbon dioxide. That case went back and forth between the trial court, which was fairly sympathetic to the plaintiffs, and the appellate court and the Supreme Court. And finally, the appellate court issued this decision saying they agreed with the plaintiffs that climate change is a terrible problem, that we ought to be dealing with it, but that it's really the job of the political branches, Congress and the president, to address climate change, that it is not the job of the courts. So the appellate court said the case should be dismissed. There was a strong dissent from one of the judges who said that the courts should continue to take that case and try it. So the plaintiffs, these young people, are now back in front of the trial court, trying to amend their complaint to seek more modest relief rather than an order from the court to that the federal government come up with a plan to slash greenhouse gas emissions. They merely want a declaration that of their rights, and saying that the federal government ought to act, but not a direction that they should. So we'll see what happens with that. Another kind of litigation that we are seeing increasingly concerns the failure to adapt, failure to prepare for the climate change that we know is coming. Two of these prominent cases have been brought by a group in Boston called the Conservation Law Foundation. One of them is brought against Exxon, which has an oil tank farm on a river near Boston Harbor. And the case is not about the emissions from the fossil fuels that Exxon produces. Instead, it's saying that this tank farm containing, storing large amounts of oil is vulnerable to coastal storms, that the tanks might burst or at least leak, causing a major oil spill, and alleging that the company has not taken enough precautions against that possibility. They have a similar lawsuit against Shell Oil over Shell's a similar facility in Rhode Island, and there are two other of these lawsuits that are that have been brought by this same organization. Another failure to adapt case arose out of Hurricane Harvey, which was a major hurricane that hit the area of Houston, Texas. There was a chemical plant called Arkema that exploded because its power supply went off, and it caused damage, it caused injury, and there are lawsuits alleging that the company did not take enough precautions against this foreseeable event. And then finally, there have been many wildfires in the state of California. The the largest electric utility there, PG&E, has been accused of having caused some of the fires because of sparks from their transmission lines. and there is litigation against them in a number of on a number of different theories. But one of them saying they did not take adequate precautions to prevent these sparks from causing or worsening wildfires. So I think we'll see a lot more of this failure to adapt litigation as the climate continues to get worse and we have more heat waves and wildfires and extreme storms and so forth. So that's my brief summary of U.S. climate change litigation.